Welcome to the Villasis Law Center Special Lectures. And I am Attorney Enrique Dela Cruz. I'd like to thank Attorney Kit Villasis for inviting me and giving me an opportunity to speak to you through this online lecture series. The topic assigned to me today is on the People's Initiative and the ABS-CBN case. Since this is a law review online lecture, I will no longer talk about the facts on the ABS-CBN case, and I'd like to concentrate on the People's Initiative and how it can be used for securing a franchise for ABS-CBN. So let's go to the basics. And I prepared a simple PowerPoint presentation to assist us in understanding the topic. Allow me to begin. So, People's Initiative and the ABS-CBN case. So let's begin with fundamentals. What is People's Initiative? Now, under the law, RA 6735, it was defined as the power of the people to propose amendments to the Constitution or to propose and enact legislations through an election called for the purpose. This is a direct exercise by the people, no? The basis is Article 6, Section 1 of the Constitution. Under this provision, legislative power is vested by the Constitution in Congress, the Senate, and the House. But this power to legislate laws has a reservation, has a limitation under the Constitution. And that is, except to the extent reserved to the people by the provision on initiative and referendum. Kaya ang kapangyarihan ng Kongreso na gumawa ng batas ay limitado sa probisyong ito dahil may kapangyarihan ang taong bayan na direktang gumawa ng batas. At ito ay nagmumula mismo sa ating saligang batas o ang ating konstitusyon. Now, susunod or next, what are the three systems of People's Initiative? Under the implementing law, which is RA 6735, we have three systems contemplated under the law. The first system is the initiative on the Constitution, which refers to a petition proposing amendments to the Constitution, which is our supreme law. Second, initiative on statutes, national laws, which refers to a petition proposing to enact a national legislation. So if Congress, both Senate and House, doesn't want to pass a law, the people directly can petition for the law to be enacted, either directly or indirectly, which I will discuss later. And the third system is called Initiative on Local Legislation, which refers to a petition proposing to enact ordinances by local government units. The same principle applies to that of a national law. So in case your local government unit, the local sanggunian, doesn't want to pass an ordinance or they enacted an ordinance which the people would want to repeal, they can do so directly through People's Initiative. And this is under Section 3A of Republic Act 6735 or the Initiative and Referendum Law. The next question is, since among the systems, you have revision of the Constitution as provided for under the law, can the Constitution be revised directly by the people through People's Initiative? The Supreme Court has answered this question in several cases, and the answer is no. According to the Supreme Court, the law as currently written, RA 6735, applies only to initiative and referendum on national and local laws. Under the law, initiative on the Constitution is confined only to proposals to amend. And in the recent case of Lambino versus Comelec, the Supreme Court said that revisions cannot be done through initiative. But in all of these cases, the Supreme Court affirmed the value of RA 6735 as a national law implementing the constitutional provision allowing the people directly to propose national laws. Now, what is indirect initiative? Under RA 6735, the people can also enact laws indirectly by submitting their proposal to Congress, acting as a legislative body to take action on a proposed legislation. Can it be done in the case of ABS-CBN? Well, most likely, yes, it can be done, but most likely, Congress will not take it up because they already ruled, at least the committee has already ruled that ABS-CBN should not be given a franchise. So indirect initiative will still require the participation of Congress. Now, how do we distinguish initiative from referendum? Because the law is entitled Initiative and Referendum Law. The initiative is the power of the people to propose amendments to the Constitution or to propose and enact national laws through an election called for the purpose. The referendum part is the power of the electorate, the registered voters, to approve or reject this proposed national law in an election called for that purpose, which we call a referendum. And this is provided under RA 6735. Now, who may exercise the power of initiative? For a national law, all registered voters in the whole country can participate. For local laws, you can have the registered voters in the autonomous regions, the provinces, cities, municipalities, and barangays. And when we say of registered voters, pursuant to the latest census of the COMELEC of registered voters as of 2019, we have 61,843,750 registered voters in the Philippines. More or less 62 million registered voters. Here in the Philippines, we still have around 1.8 million absentee voters abroad. So how can a person participate in this initiative? Well, the COMELEC is required by law to set a special registration day at least 3 weeks before a scheduled initiative or referendum. And any interested person may then register and sign a petition for initiative. And even if you do not register in this special registration days, as long as you have participated in the immediately preceding election, therefore your name is in the COMELEC database as a registered voter, you can participate in a people's initiative. Now, what are the requirements on the exercise of this power of initiative on a national law? Now, under the law, RA 6735, to exercise the power of initiative to enact a national law, you have two requirements. You need to gather signatures of registered voters all over the country. You need 10% of the total number of registered voters. So if you have around 62 million registered voters, you need around 6.2 million signatures. And the second requirement is that every legislative district should be represented by at least 3% of the registered voters in that district. So how does this goes? You have 10% of the total registered voters all over the country, which is 6.2 million, and it must be distributed in such a way that each legislative district all over the country should have at least 3% of its registered voters represented in that pool of signatures. Now, what are excluded from the power of initiative on a national law? Under the law, Congress has placed these prohibitions or restrictions. There are only two restrictions. Number one, no petition embracing more than one subject shall be submitted to the electorate. So, there must be one subject, one title. No? So, one subject matter per proposed legislation. And second, laws or statutes involving emergency measures, the enactment of which are specifically vested in Congress by the Constitution, cannot be subject to referendum until 90 days after its effectivity. So, this applies only to emergency measures, like the Bayanihan Act, for example. That is an emergency measure. or an emergency power bill granting emergency powers to the President. That is reserved for Congress, and that is found in the law implementing the power of the people to directly propose laws under Section 10 of RA 6735. Now, can a private bill like the franchise of ABS-CBN be allowed in a people's initiative? The answer is yes. Why? Because if the Constitution allows the use of people's initiative to introduce amendments to the Constitution itself, which is our supreme law, the highest law of the land, if it can be amended through people's initiative, then there is no logical reason to exclude a mere private bill from the coverage of people's initiative. Remember that Congress enacted RA 6735, and they placed only 2 exclusions from the power of people's initiative. And a private bill is not one of them. So by its own limitations, Congress enacted this law. Private bills are not excluded from the power of the people in an initiative and referendum. And we must understand the basis of people's initiative. The people's initiative is based on the power of the people directly to propose national laws, sapagkat ang kapangyarihang gumawa ng batas ay galing sa taong bayan. Kapag taong bayan na ang kumukuha nito, hindi po ito pwedeng limitahan ng Kongreso at sabihin, hindi nyo pwedeng gawin yan dahil private bill yan. Tandaan po natin na sa saligang batas mismo natin nakasaad na ang kapangyarihan ay nagmumula at nanggagaling sa taong bayan. So, the reason why people are objecting to people's initiative is because there is a provision under Article 6, Section 24, which states that private bills, along with appropriation bills, revenue bills, bills increasing public debts, and local bills, are required by the Constitution to originate exclusively from the House of Representatives. So the critics are saying, how can a private bill, which is mentioned under Article 6, Section 24, like a franchise granting ABS-CBN the power to broadcast, be allowed in a people's initiative? Well, the answer is simple. Article 6, Section 24 is a limitation on Congress in enacting a national law. It is a limitation by the Constitution telling Congress, for this kind of bills, it must originate from the House. That is a limitation on Congress itself. But that doesn't apply to the exercise of people's initiative. Why? Because sovereignty resides in the people and all government authority emanates from the people. Under Article 6, Section 1, the power of Congress to legislate is limited by that reservation of the people's exercise of initiative. Since the power comes from the people, Congress cannot have more powers than the people. Thus, the river cannot rise higher than its source. If the source of the power is the people, and the power to legislate is simply delegated to Congress, Congress cannot presume that it has more power than the people from whom that power originates. So take note that under Article 6, Section 1, it says, it recognizes the distinction between original and derivative legislative power by declaring that legislative power shall be vested in Congress, except to the extent reserved to the people by the provision on initiative and referendum. This italized clause, the except to the extent reserved to the people by the provision on initiative and referendum, pertains to the original power of legislation, which the sovereign people have reserved for their exercise in matters they consider fit. Considering that derivative legislative power is merely delegated by the people to Congress, it is deemed subordinate to the original power of the people. And this is the explanation of the Supreme Court in Garcia versus Comelec, a case decided in 1994. Under this decision, the Supreme Court said that the power of the people to legislate is higher than the power of Congress. Now, a people's initiative will require a national referendum. And some election law experts estimate that this will need billions of pesos. Can this push through even without a budget allocation from COMELEC? Even if the COMELEC says it has no budget for this? Well, the Supreme Court has already answered this question. In the case of Marmeto versus COMELEC, the Supreme Court ruled that initiative and referendum are the means by which the sovereign people exercise their legislative power, and the valid exercise thereof should not be easily defeated by claiming lack of budgetary appropriation for their conduct. In this case of Marmeto versus COMELEC, Marmeto was proposing an ordinance in the City Council of Muntinlupa. The City Council said that they don't want to pass the proposed ordinance. And so Marmeto filed a petition with the required signatures with the COMELEC. But the COMELEC denied the petition on the ground that it has no budget to organize and set up and facilitate a referendum for that initiative. It reached the Supreme Court, and this was the ruling of the Supreme Court. The Supreme Court reiterated that in the annual budget of COMELEC, there is always a line item there for the conduct and supervision of election, generic. And so the Supreme Court said this generic line item allocation in the budget of Congress constitutes sufficient authority for the COMELEC to use whatever amount is there for elections and other political exercises, which can include initiative and referendum and even recall, to augment this amount from the COMELEC's existing savings. So the COMELEC can add to this line item from whatever savings it has in its other allocations. So lack of budget cannot be used as an excuse to deny the people their right to exercise a valid petition for initiative. Marmeto versus COMELEC. Now, who will verify the authenticity of the signatures, the 10% and 3% per district? Under the law, the election registrar in each municipality or city shall verify the signatures on the basis of the registry list of voters. And this is the usual job of COMELEC, verifying these signatures. This is to ensure that only registered voters have signed the petition and that the signatures therein are genuine. So this is the way to verify whether the signatures attached to the petition are genuine. And what is the timeline? Some people are saying we might not have enough time. We have elections scheduled in 2022. This might take so much time. Well, the law already set a specific schedule. Under Section 8 of RA 6735, within a period of 30 days from receipt of the petition, the COMELEC should publish it once it is convinced that it has sufficiency in form and substance. And after it has published the petition, it must set the date of the initiative or referendum, which should not be earlier than 45 days but not later than 90 days. So you have 30 days and 90 days, or a total of 120 days from the time that the COMELEC receives the petition and there is a determination that it is sufficient in form and in substance. So you have it. You have a timeline. And this timeline is provided already by the law. So it will not take 2 years. From the time it is received by the COMELEC, you have a specific period already set by the law. Now, when will the law enacted by People's Initiative take effect? Now, under the law, Section 9, if, as certified by the COMELEC, that this has been approved by a majority of the votes cast, so there will be campaigning, there will be a period where the advocates for and against will be allowed to convince the registered voters, and then a day will be set where the registered voters can vote on this proposed measure. And if the majority of the votes cast favor the enactment of this franchise for ABS-CBN, then following its publication, in the official gazette, no, it shall become effective 15 days after publication. Question: what if the President does not sign it? Or what if he vetoes it? The good thing about this, the President cannot veto a law enacted by the people through people's initiative, because that will defeat the purpose of a people's initiative. Also, Congress cannot amend or repeal while there is no specific provision in the Constitution or the law saying this. It makes sense. If Congress can simply repeal or amend a law enacted by the people through people's initiative, then it will defeat the whole purpose of a people's initiative. But I accept that all of these theories are just theories. These are the language of the law. The Supreme Court has not yet interpreted these provisions, and we look forward to an actual case that will be filed or may be filed in the Supreme Court, so that the Supreme Court can decide with finality on these legal issues. Until then, we can rely on the language of the law, and if the question is asked, can a private bill granting a franchise to ABS-CBN be enacted through people's initiative? The answer is yes, and I've laid down the legal basis why. Muli, maraming salamat po sa pag-imbita dito po sa Villasis Law Center online lecture series. Sana po ay meron kayong natutunan sa ating maigsing talakayan tungkol sa People's Initiative. Muli, ako po si Atty. Enrique Dela Cruz. Maraming salamat. Magandang hapon po sa inyong lahat.